She was standing at the end of my driveway with a clipboard, a violation notice, already filled in. She told me the property had been vacant over a year, and the HOA had placed it under community maintenance. She told me I needed to identify myself and cease unloading until the situation was clarified through proper HOA process. I told her my name, Walter Greer. I told her I've owned this property since August 14th, 1987. She told me that was not possible, so I asked her one question. Which recorded instrument gives the Harborview Estates HOA jurisdiction over my land? She cited the governing documents. I told her my deed predates your HOA by 4 years. You're not in my plat. I'm not in yours. She called 911 anyway. The deputy ran the parcels before he got out of the unit. Then he drove to her window and asked one question. Ma'am, did you know the man you just called 911 on owns the road you drove in on? Let's get things rolling from the beginning. Where are you joining from today? Let me know, and don't forget to like and subscribe. Walter Greer had owned the lake house on Alderman Point since August of 1987, 38 years. The deed recorded in Macon County before the first subdivision lot on the point had been staked, before the developer who would build Harborview Estates had so much as driven the road, before anyone had thought to form a homeowners association for a neighborhood that did not yet exist. He had bought the property from his father's estate. The Greer family had held land on Alderman Point since 1962. His father had bought the original 11-acre parcel from a timber company that had finished its cut and moved on, and had built the lake house the following summer, a 4-bedroom structure on the western shore of Caldwell Lake, with a screened porch facing east toward the water, and a dock that extended 40 feet into the lake at the point's natural cove. Walter had grown up spending summers on that porch. He had inherited the property and expanded the holding over the years, acquiring adjacent parcels as they became available, until the Greer family's presence on Alderman Point comprised 4 separately deeded parcels that together covered the westernmost portion of the point from the county road turnoff to the lake shore. He had been a real estate developer for 41 years. He understood property. He understood deeds, recorded instruments, plat boundaries, easement language, and the specific legal architecture that determined what a person owned and what they did not own, and what an HOA could and could not do with the authority a covenant document gave it. He had retired 3 years ago. He had intended to return to the lake house within 6 months of retirement. A health matter, a cardiac event in November of his retirement year, followed by a recovery period that stretched longer than his cardiologist had initially estimated, had kept him in Raleigh. He had managed the property from a distance, taxes paid annually, insurance maintained, a local property manager checking the exterior monthly and reporting any issues. The property had sat vacant for 3 years. That was a fact. It was the only fact about the property's status that was accurate. The 4 parcels were separately deeded and separately assessed, each with its own parcel number in the Macon County tax records and its own deed book and page in the county recorder's index. The first parcel, MC-1987-0041, was the main lake house parcel, 2.3 acres on the western shore, the house sitting 80 feet back from the high water mark, the screened porch his father had built in 1963, still structurally sound and repainted twice in the intervening decades. The deed was recorded August 14, 1987, Walter Greer as grantee, the legal description running from the lakeshore west to the road parcel boundary. The second parcel, MC-1987-0042, was the carriage house parcel immediately north of the main house. 1.1 acres, the carriage house a 2-bay structure built by Walter in 1993 to house the equipment and vehicles the property required. It sat on its own deed, separately assessed, its northern boundary running along the line that separated the Greer holdings from the first Harborview Estates lot platted in 1991. The carriage house parcel had been in Walter's name since 1987, purchased as raw land and improved over the following decade. The third parcel, MC-1987-0043, was the lakefront access parcel, a strip of land running 340 feet of Caldwell Lake shoreline south of the main house parcel, the strip 60 feet wide from the high water mark west to the road parcel boundary. Walter had purchased it in 1989 from a family that had owned it since the 1940s and had no interest in building on it. The dock was on this parcel. The boat storage was on this parcel. The 340 feet of Caldwell Lake shoreline that made the Greer holding a complete lakefront property, rather than a house with a limited water view, was on this parcel. The fourth parcel, MC-1987-0044, was the road parcel. This was the one that mattered most. This was the one Beverly Marsh had apparently never looked up. Alderman Point Road was the only paved road serving the Point's 22 residential lots. It ran from the County Road turnoff at the Point's base, east and north along the western shore, serving all 22 lots before terminating in a cul-de-sac at the Point's tip. Every vehicle that accessed Alderman Point, every resident, every visitor, every delivery truck, every contractor, used this road. There was no other way in. There was no other way out. The road parcel was a 60-foot wide strip of land running the full length of Alderman Point Road. The land beneath the road surface, the 30-foot buffer strips on each side of the road center line, the complete underlying fee interest in the corridor that the road occupied. Walter's father had conveyed the road surface to Macon County in 1994 under a donation instrument, a 2-page document recorded in the county deed book that transferred the county's maintenance obligation to the road surface and gave the county the easement rights necessary to maintain, repair, and improve the pavement. The county had accepted the surface and had been maintaining it since. The road was patched and resurfaced on the county's schedule, the county's road maintenance crew responsible for the pavement and the drainage structures. But the 1994 donation instrument had contained a reservation clause. Walter's father had not conveyed the underlying fee interest. He had donated the surface and retained the land. The reservation language was on the instrument's second page, 3 sentences that the Greer family attorney had insisted on including, and that the county had accepted without objection, because the county's interest was in maintaining the road surface, not in owning the land beneath it. The reservation read, "The grantor retains fee simple title to the road parcel, identified as parcel MC-1987-0044, subject only to the county's surface maintenance easement and the access easement recorded contemporaneously herewith in favor of the Harborview Estates lots." Walter Greer owned the land beneath Alderman Point Road. He owned the 30-foot buffer strips on each side. He owned the fee interest in the corridor that every vehicle on the point drove through every time it came or went. He had owned it since 1987. The deed index said so. The tax records said so. The reservation clause in the 1994 donation instrument said so. He had paid the property taxes on parcel MC-1987-0044 every year since 1987. The tax bills were modest. The parcel produced no income, and the county's assessed value for road corridor land was low. But the bills had arrived every January, and Walter had paid them every January, for 38 years without interruption. The Harborview Estates development had been the work of a Charlotte developer named Bryce Tillman, who had approached Walter's father in 1989 about purchasing the undeveloped lots on Alderman Point. Walter's father had sold 18 of the 22 lots. The lots that ran along the eastern and northern portions of the point, the lots with lake views but without the Greer family's primary lakefront position, and had retained the 4 parcels that comprised the family's core holding. The sale had been structured carefully, Walter's father working with the Greer family attorney to ensure that the road parcel reservation, the lakefront access parcel, and the primary house parcel were explicitly carved out of the transaction. Bryce Tillman had platted the 18 lots as Harborview Estates in 1991 and formed the HOA simultaneously, a standard covenant community structure. The HOA governing the 18 platted lots and the common areas Tillman had dedicated within the subdivision. The covenants were recorded in November 1991. Walter's 4 parcels were not in the plat. They were not referenced in the covenants. They were not subject to the HOA's governance in any respect. Walter had read the covenants when they were recorded and confirmed what he already knew. He was outside them, the same way he was outside every development that had grown up around Greer family land in Macon County. The HOA had governed the 18 lots for 35 years without incident. The normal business of a lakefront covenant community, the dock regulations and exterior standards, and the noise ordinance the board had adopted in 2003 after a summer of complaints. Walter had watched it operate from his porch across 3 decades and had no complaint with it. The 18 households on Alderman Point were his neighbors. He had known many of their owners over the years. The HOA's business was the HOA's business, and his property was his property, and the line between them was in the deed index. Beverly Marsh had become HOA president 2 years ago, and had apparently decided that the line in the deed index was less relevant than what she could see from the community entrance road. Walter arrived on a Wednesday afternoon in late August. He had hired a moving company out of Raleigh, a 3-man crew with a 26-foot truck. The truck loaded over 2 days with the contents of the Raleigh apartment, and the boxes of files and property records, and the furniture that Walter had accumulated over 41 years of real estate work and 3 years of recovery. He had driven his own vehicle, a pickup truck, the truck he used for property work, ahead of the moving crew, arriving at Alderman Point Road at 2:40 p.m. He had stopped at the County Road turnoff and looked east along the Point Road toward the lake house. The road looked the same. The point looked the same. The Harborview Estates entrance sign was where it had always been, a brick monument at the Point Road's intersection with the County Road, the sign reading Harborview Estates in raised letters, the HOA's landscaping around the base of the monument trimmed and tended. Walter had always found it faintly amusing that the subdivision's entrance sign sat 40 feet inside his road parcel, technically on the buffer strip that was part of parcel MC-1987-0044, the sign base sitting on land he owned, placed there by a developer who had purchased the lots from his father and apparently not read the reservation clause carefully enough to realize the entrance monument was not on Harborview Estates property. He had never said anything about the sign. He had no objection to it. It was not harming his land, and the HOA maintained it, and it was the kind of thing that reasonable people let sit when the alternative was a dispute over a brick monument that served a legitimate purpose. He drove to the lake house. He unlocked the front door. The key, the same key he had used since 1987. The lock, the same lock. The door opening onto the interior that smelled of the particular stillness of a closed house in a warm August, and walked through the rooms. The property manager had done her job. The interior was clean. The porch screens were intact. The dock was in place, the flotation still sound, the tie cleats in good condition. He went back outside and waited for the moving truck. The crew arrived at 3:15 p.m. They backed the truck into the driveway that ran from the road parcel's edge to the carriage house, the truck fitting without difficulty. The cones the crew set out at the driveway's road approach, sitting on the road parcel's buffer strip, Walter's land, as they had every legal right to do. The crew began unloading at 3:20 p.m. Beverly Marsh's car appeared at the end of the driveway at 3:44 p.m. She had seen the moving truck from wherever she had been when it came down Alderman Point Road. She had seen it turn into Walter's driveway. She had seen the crew unloading boxes and furniture into the lake house that had been vacant for 3 years. And she had driven to the property line within 25 minutes with a clipboard and a printed violation notice and the particular conviction of a person who had confused her HOA authority with a general license to supervise everything she could see from the community road. Walter set down the box he was carrying, a box of property files, the records he had kept for 38 years of ownership on these 4 parcels, the deeds and the tax records and the insurance documents and the recorded instruments that said everything that needed to be said about who owned what on Alderman Point. He turned to face her. He had been a real estate developer for 41 years. He had read more property documents than Beverly Marsh would read in 10 lifetimes. He owned the driveway she was standing at the edge of, the road she had driven in on, and 340 feet of Caldwell Lake shoreline. He waited to hear what she had to say. Beverly Marsh was wearing the Harborview Estates HOA polo shirt. It was navy blue, the same color the Pinecrest Ridge board wore, the same color every HOA board in every lakefront covenant community in western North Carolina seemed to settle on, as though the color had been selected at a national HOA conference decades ago, and the decision had never been revisited. The embroidered logo on the left chest, Harborview Estates HOA, the letters arced above a small stylized rendering of a dock and water. She was wearing it on a Wednesday afternoon in late August, as though she had put it on specifically for this occasion, which Walter suspected she had. The polo was the uniform of HOA authority. You wore it when you were going somewhere to enforce something. She had the clipboard. She had a printed violation notice, a pre-formatted document with the Harborview Estates HOA letterhead at the top, and fillable fields for the property address, the nature of the violation, the required corrective action, and the compliance deadline. The fields had been filled in. She had filled them in before she drove to his driveway. She had decided what the violation was before she arrived to investigate whether there was one. Walter watched her walk from her car to the property line. She stopped at the line, the boundary between his driveway and the road parcel buffer strip, the edge of the driveway apron where the gravel met the grass. She did not step onto the driveway. She stood at the line with the clipboard held at chest height and waited for him to come to her. He did not come to her. He set the box he was carrying, a box of kitchen items, plates and glasses wrapped in paper, the box heavy enough that setting it down was a practical decision as much as a deliberate one, on the tailgate of the moving truck and walked toward her at a pace that was unhurried without being slow. He covered the distance in 12 steps. He stopped at a conversational distance on his side of the line. He looked at the polo shirt. He looked at the clipboard. He looked at the violation notice with its filled-in fields. He looked at Beverly Marsh. He said nothing. He waited. She told him the moving truck was blocking community access. Walter looked at the moving truck. It was backed into the driveway at an angle that left the full width of Alderman Point Road clear in both directions. The road, his road parcel, the land he had owned since 1987, the surface maintained by Macon County under the 1994 donation instrument, was completely unobstructed. A vehicle could pass freely in both directions without adjusting speed or position. There was no obstruction. There was a moving truck in a private driveway that was visible from the road, which was a different thing entirely. He told her the road was clear. She told him the property had been unoccupied for an extended period, and that the HOA had been maintaining it under the community's abandoned property provision for the past 18 months. She told him there were protocols for reoccupying a property that had been in HOA maintenance status. She told him he needed to identify himself and explain what he was doing on this property before any unloading continued. Walter looked at her for a moment. He had spent 41 years in real estate development. He had dealt with HOA boards, covenant disputes, easement negotiations, title questions, and the full range of situations that arose when property changed hands, or sat vacant, or became the subject of competing claims about who had authority over it. He recognized the specific type of conversation he was in. He had been in it before, though usually on the other side of the table, with better documentation than he was facing now. He told her his name, Walter Greer. He told her this was his property. He told her he had owned it since August 14th, 1987, and that he was moving in permanently after an extended absence necessitated by a health matter. He told her the deed was in his name. The taxes were current, the insurance was current, and the property had never been abandoned in any legal sense of the word. She told him that was not possible. He asked her why not. She told him the property had been in HOA maintenance status for 18 months. She told him the board had voted to place it in that status under the community's abandoned property provision, after the property had been vacant for over a year without any apparent owner activity. She told him the HOA had been mowing the lawn and maintaining the exterior. She told him, and here her voice took on the particular firmness of someone who has rehearsed a position and intends to deliver it regardless of the response, that he needed to cease the unloading activity and leave the property until the situation could be clarified through the proper HOA process. Walter told her he was not going to do that. She told him he needed to understand that the HOA had jurisdiction over this property under the abandoned property provision, and that she was the HOA president, and she was telling him to stop. He asked her which recorded instrument gave the Harborview Estates HOA jurisdiction over his property. She told him the HOA's governing documents. He asked her which page of the governing documents covered properties that were not in the Harborview Estates recorded plat. She told him all properties on Alderman Point were subject to the community standards. He told her his parcels predated the HOA's formation by 4 years, and were not in the plat and were not subject to any covenant the HOA had ever recorded, and that if she had a document that said otherwise, he would be glad to read it. She did not produce a document. She told him he was being uncooperative. She told him the community depended on consistent standards across all properties on the point. She told him the past 18 months of HOA maintenance activity on his property was evidence of the community's investment in the point's appearance, and that he should appreciate it rather than challenge it. Walter told her he had not asked anyone to maintain his property. He told her his property manager had been checking the exterior monthly, and that the property had been adequately maintained without HOA involvement. Beverly's jaw tightened. She had arrived with a filled-in violation notice, and a position she had developed without looking up a single deed. She had come to enforce something at a vacant property, and found a 68-year-old man in work clothes who was not moved by the polo shirt or the clipboard or the word jurisdiction. She told him she was going to give him one more opportunity to cease the unloading and leave voluntarily. He told her this block was his. He turned, picked up the box from the tailgate, and walked back to the house. Beverly Marsh called Macon County Dispatch at 4:47 p.m. Walter heard her on the phone from the porch. He was carrying a box through the front door and could hear her voice from the driveway line, the particular compressed urgency of someone reporting an incident to a dispatcher. He set the box inside the door and stood on the porch for a moment, listening to what he could hear of the call. He heard the word trespassing. He heard the words refusing to leave. He heard vacant property. He heard HOA managed. He did not hear his name. She had not given the dispatcher his name, which meant she was reporting the situation without identifying the person she was reporting as the individual who had told her he was the owner of record. He went back inside and picked up his own phone. He called James Whitfield. James Whitfield had been practicing property law in Macon County for 22 years. He had represented the Greer family's real estate interests for all 22 of those years. He had handled the 1994 road surface donation instrument, the access easement recorded contemporaneously with it, 3 boundary line adjustments between the Greer parcels over the years, and the tax assessment appeals Walter had filed in 2009 and 2014, when the county had reassessed the lakefront access parcel at a value Walter believed was not supportable by the comparable sales data. James knew the 4 parcel deeds the way a physician knew a long-term patient's chart, not from having read them recently, but from having been present for everything that had happened to them. Walter told him the situation in 4 sentences. Moving in, HOA president claiming jurisdiction, 911 call made, deputy en route. James was quiet for 2 seconds. Then he said, "Which parcel is she claiming authority over?" Walter told him all 4. James said, "She hasn't looked at the road parcel." Walter told him he did not think she had looked at any of them. James told him he was leaving the office now. He told Walter to find his copy of the deed to parcel MC-1987-0041, the main lake house parcel, and have it ready. He told him to have his driver's license ready. He told him to continue unloading and not engage Beverly Marsh further until the deputy arrived. Walter told him the box of property files was already on the truck. James said, "Of course it is." He ended the call. The moving crew had continued working during the conversation at the property line and the phone calls that followed. They were professionals. They had been moving people in and out of properties for years, and they had seen disputed arrivals before. The domestic tensions and the complicated situations that sometimes attended the moment when a household's contents arrived at a new address. They moved boxes and furniture with the steady efficiency of men who were paid by the job and who had learned not to ask questions about the circumstances. Walter went back to work alongside them. He carried boxes from the truck to the house, the kitchen boxes, the linen boxes, the box of property files that he set on the kitchen table without unpacking, knowing he would need it within the hour. He directed the crew on the furniture, the living room arrangement he had planned during the drive from Raleigh, the bedroom furniture going upstairs, the office furniture going into the room that had been his father's study and that Walter intended to use the same way. Beverly Marsh was still at the property line. She had ended the 911 call and was standing with the clipboard, watching the unloading continue. She made no further approach. She had said what she had come to say and had called for the reinforcement she believed would resolve the situation in her favor, and now she was waiting. Walter was aware of her the same way he was always aware of things happening at the edge of a property he was managing, noting the position, noting the stillness, noting the fact that the clipboard was no longer being referenced, the violation notice no longer being consulted. She was waiting. He was working. At 5:02 p.m., a Macon County Sheriff's Office patrol unit turned onto Alderman Point Road from the County Road turnoff. Walter saw it from the porch. The unit's roof lights not running. The approach calm and professional. The deputy driving at the pace of someone arriving at a property dispute rather than an emergency. The unit came down Alderman Point Road and stopped on the road surface in front of the driveway. The deputy got out. Walter noted, from the porch, that the deputy had stopped his unit on Alderman Point Road, the road surface maintained by Macon County, the road parcel owned by Walter Greer. The land beneath the deputy's unit, parcel MC-1987-0044, fee simple title, Walter Greer, deed recorded August 14, 1987. He went inside and got the box of property files. He was going to need the road parcel deed. Macon County Dispatch had logged the call at 4:48 p.m., 1 minute after Beverly placed it. The call description read, "Unknown individual unloading moving truck at vacant HOA managed property, Alderman Point Road. Individual refusing to leave. Possible trespass." The call had been assigned to Deputy Aaron Fitch, 6 years with the department, a solid record, the kind of deputy who read a situation before he committed to a response. He had been 3 miles from the point turnoff when the call came in. His supervisor on the shift was Sergeant Linda Cole. She had 14 years with the Macon County Sheriff's Office and had grown up 2 miles from Caldwell Lake. She had swum in that lake as a child, had driven Alderman Point Road as a teenager, knew the point the way you knew places that had been part of your geography since before you were old enough to understand property lines. When the call came across her radio, she had looked at the address and looked at the call description and picked up her radio. She had called Aaron directly. She told him she knew that property. She told him to check the deed records before he drew any conclusions on scene. She told him Alderman Point had some unusual ownership history and that the call description did not sound complete to her. Aaron told her he would run the parcels before he got out of the unit. He had already been doing exactly that. Aaron Fitch had run the parcel numbers before he got out of the unit. Sergeant Cole's radio call had been specific enough that he had pulled up the Macon County GIS on his MDT while still on the county road, typing the address into the parcel search before he made the turn onto Alderman Point Road. The search had returned 4 results, all registered to the same owner. He had looked at the 4 parcel numbers and the owner name and the recording dates, and had sat with that information for the 30 seconds it took him to turn onto the Point Road and begin the approach. He drove Alderman Point Road at a speed that let him look at it. He noted the entrance monument, the Harborview Estates brick structure at the road's junction with the county road, the HOA signage, the landscaping maintained around the base. He noted the road surface, county pavement, the yellow center line faded but present, the road in the condition of a county-maintained rural road that got resurfaced on the county's schedule, and not before. He noted the lots on either side, the Harborview Estates homes visible behind their setbacks, the docks extending into the lake on the eastern side, where the lots had water frontage, the Greer Lake House, visible ahead on the western shore, the moving truck backed into the driveway with the crew still working. He noted the GIS overlay on his MDT screen as he drove, the parcel boundaries rendered on the aerial base map, the road parcel boundary visible as a 60-foot wide corridor running the full length of the road he was driving on. The owner name on the road parcel was the same owner name on the other 3 parcels. He looked at the road beneath his unit's tires. He looked at the MDT screen. He drove to the front of the moving truck and stopped. He sat in the unit for 30 seconds before he got out, finishing the GIS review. 4 parcels, Walter Greer, all 4. Recording dates ranging from August 1987 to a secondary instrument in 1989. The HOA formation date visible in the county records, November 1991. He noted the 4-year gap between the oldest Greer deed and the HOA's formation. He noted the road parcel's dimensions, 60 feet wide, running the full length of Alderman Point Road from the county road junction to the cul-de-sac at the point's tip. He got out of the unit. He introduced himself to Beverly Marsh first. Standard procedure. The complainant received the initial contact. The responding officer established the nature of the call before approaching the subject of the complaint. Beverly was standing at the property line with the clipboard and the filled-in violation notice, and the expression of someone who has been waiting for the reinforcement that would resolve the situation in her favor. Aaron introduced himself. He asked her to walk him through the complaint. She told him in the compressed, efficient manner of someone who had been rehearsing the account while waiting. Moving truck at the vacant property. Unknown individual unloading. Individual claiming to be the owner. Individual refusing to leave when asked. The property had been in HOA maintenance status for 18 months under the community's abandoned property provision. She was the HOA president. She had authority over the property. The individual was trespassing. Aaron wrote in his field notebook. He asked clarifying questions. The specific manner in which the truck was blocking access, which she could not demonstrate because the road was clearly passable. The specific instrument that established the HOA's authority over the property, which she described as the HOA's governing documents. The specific document that authorized the abandoned property provision, which she said was in the HOA's board resolution records. He asked whether she had those documents with her. She said she had the violation notice. He looked at the violation notice on her clipboard. He noted the property address. He noted the violation description, unauthorized occupancy of HOA maintained property. He noted the compliance action, cease and desist unloading, vacate property pending HOA review. He asked whether the property was in the Harborview Estates recorded plat. She told him all properties on Alderman Point were subject to HOA standards. He wrote that down. Then he told her he was going to speak with the individual and he would come back to her. He walked up the driveway to where Walter was standing at the moving truck's tailgate. Walter had a folder in his hand. Aaron had not finished his introduction before Walter opened the folder and laid 3 documents on the tailgate in front of him. The first was his driver's license, North Carolina, the address showing a Raleigh street that Aaron noted did not match the Alderman Point Road address, a detail consistent with someone relocating, rather than someone attempting to occupy a property they did not own. The second was the deed to parcel MC-1987-0041, the main lake house parcel, 2 pages, the legal description running from the high water mark of Caldwell Lake west to the road parcel boundary, the grantee, Walter Allen Greer, the recording date, August 14th, 1987. The deed was a certified copy from the county recorder's office, the certification stamp visible in the lower right corner. The third document was a single page, a summary that Walter's phone showed had been emailed from James Whitfield's office 7 minutes earlier and printed on the small thermal printer mounted in the moving truck's cab. Aaron looked at the printer, a compact unit velcroed to the dash, the kind of equipment a man who moved property documents around routinely would have installed in his work vehicle. The printed page listed 4 parcel numbers in sequence, MC-1987-0041 through MC-1987-0044. For each parcel, the deed book and page, the recording date, the legal description summary, and the acreage. The recording dates for all 4 parcels ranged from August 1987 to June 1989. The HOA formation date, November 1991, was noted at the bottom of the page with a single line. All 4 Greer parcels predate HOA formation by a minimum of 2 years. None are within the Harborview Estates recorded plat boundary. Aaron read the summary. He read it twice. He looked at the deed. He looked at the driver's license. He looked at Walter. Walter told him he had owned the property since August of 1987 and had been absent for 3 years due to a health matter and was returning as a permanent resident. Aaron told him he would be right back. He walked to his unit. He ran the full GIS query on his MDT, all 4 parcel numbers, the boundary overlays, the ownership records, the deed book references. The system returned the same data he had previewed during the approach, now fully rendered with the boundary layers visible against the aerial photograph base. He looked at parcel MC-1987-0044 for a long time. The road parcel boundary was unmistakable on the GIS overlay. The 60-foot corridor running from the county road junction, the full length of Alderman Point Road. The boundary lines on each side of the road center line perfectly parallel, the parcel encompassing the road surface, and the 30-foot buffer strips on each side. The owner of record on the parcel data panel, Walter Allen Greer. The deed reference, Book 22, page 14, Macon County. He looked at the road outside his unit's windshield. He looked at the GIS overlay. He looked at the road again. He selected the print function. The in-car printer produced the GIS map, the aerial base, the 4 parcel boundaries rendered in the overlay, the parcel numbers labeled, the owner name visible in the data panel, the scale bar at the bottom. He folded it once and got out of the unit. He walked to Beverly Marsh. He held the GIS printout out to her without preamble. She took it. He pointed to the parcel boundaries on the map. The 4 Greer parcels, their boundaries clearly delineated, the road parcel corridor visible as the long rectangular strip running the length of the point road. He told her the individual she had called about was Walter Greer, and that the county GIS showed him as the owner of record on all 4 parcels at this location. He pointed to the road parcel on the printout. He told her the GIS showed the fee interest in the road parcel, the land beneath Alderman Point Road, as registered to Walter Greer. Beverly looked at the printout. She looked at the road parcel boundary. She looked at Alderman Point Road, the road she had driven in on, the road she drove every day to reach her Harborview Estates home, the road whose surface was maintained by Macon County, but whose underlying land, according to the county's own GIS system, belonged to the man she had just called 911 on. She asked Aaron what that meant. Aaron told her carefully, the word carefully doing the work it always did when a deputy chose it, meaning precise rather than softened. He told her it meant the individual she had reported as a possible trespasser owned the property she had described as HOA managed. He told her it appeared, based on the GIS data, that the individual also owned the underlying fee interest in the road she had driven in on. He told her he could not identify a trespass on this property. He could not identify a violation of any statute that would require the individual to cease his activity or leave. Beverly's clipboard arm dropped slightly. The violation notice was still on it, the filled-in fields, the compliance deadline she had written in before she drove to the property line. She looked at it. She looked at the GIS printout. She looked at the road. She said, "He owns the road?" Aaron told her the GIS showed a fee interest in the road parcel registered to Walter Greer, and that the county maintained the road surface under a maintenance easement. He told her he was not in a position to interpret the full legal significance of that on scene, but that the county's own records showed it clearly. Beverly said nothing for a moment. The polo shirt, the clipboard, the violation notice, none of it had the weight it had carried 90 minutes ago, when she had driven to the property line with the certainty of a person who had never been wrong about her jurisdiction before, because no one had ever checked. She told Aaron the HOA had been maintaining the property for 18 months under the community's abandoned property provision. She said it with less force than she had said anything since he arrived, not as a position, more as an explanation she was offering for why she was standing here with a violation notice at a property belonging to a man who owned the road she drove home on. Aaron asked her for the recorded instrument that authorized the HOA's maintenance activity on the property. She told him it was in the HOA's board resolution records. He asked her for the recorded instrument, meaning something filed with the county recorder's office, something in the deed index, something that had the legal force of a recorded document rather than an internal board decision. She told him the board resolution was in the HOA's minutes. He asked whether the HOA had obtained a court order authorizing maintenance activity on a property it did not own, and that was not in the HOA's covenant boundary. She said the board had voted on the provision. Aaron wrote in his notebook. He wrote carefully, the date, the time, Beverly's description of the authorization basis, the absence of a recorded instrument, the absence of a court order, the absence of any documentation she could produce on scene that established the HOA's authority to conduct maintenance activity on a property outside the Harborview Estates plat. He closed the notebook. He looked at Beverly Marsh with the neutral patience of a deputy who had been doing this for 6 years, and who had learned to distinguish between a legal position and a conviction held in the absence of documentation. He told her he would need to speak with Mr. Greer further. He told her he was not making any findings yet. He told her if she had the HOA's recorded authority documentation, she should produce it, and if she did not have it on scene, she should obtain it. She said she would call the HOA's attorney. He told her that was her right. He walked back up the driveway to where Walter was standing with the property folder, the moving crew still working steadily behind him, a bedroom dresser coming down the truck's ramp as Aaron approached. Walter looked at Aaron's expression. He had been reading people across property disputes for 41 years. He asked Aaron if he wanted to see the road parcel deed. Aaron told him yes. He told him he wanted to see all four. James Whitfield drove a dark green sedan that had 180,000 miles on it, and a back seat that functioned as a mobile filing annex. Folders and document cases stacked in the order of the matters he was actively working, the system comprehensible only to him and Ruth, his paralegal, who had given up trying to impose organization on it a decade ago, and had instead developed the ability to locate any document in the stack within 45 seconds by touch alone. The folder for the Greer Alderman Point parcels was on top of the stack when he got in the car. He had pulled it from the office filing cabinet before he left. The full title package for all four parcels, assembled when Walter had first retained him in 2003, and maintained since through the boundary adjustments and the tax appeals, and the 1994 donation instrument, and everything else the four parcels had generated over 22 years of representation. He had updated the folder that afternoon before leaving the office, printing the current tax records and the current county GIS parcel data, and adding them to the front of the package. He drove the 34 minutes from the county seat to Alderman Point Road without exceeding the speed limit because he had learned, over 22 years, that arriving with the right documents mattered more than arriving fast, and he was going to arrive with the right documents regardless of what speed he drove. He turned onto Alderman Point Road at 5:51 p.m. Aaron Fitch was standing at the front of his patrol unit with Walter Greer when James pulled in. James had met Aaron Fitch twice before, both times at property disputes in the county, both times situations where Aaron had been the responding deputy, and James had been the attorney who arrived to clarify the legal architecture. Aaron remembered him. He was, James knew, a deputy who appreciated clarity and documentation, and who had the patience to read a document when one was placed in front of him. That combination was rarer in James's experience than it should have been. James shook Walter's hand first. He asked him if he was all right. Walter told him he was fine, and that the moving crew had finished the truck by 5:30 and were waiting to be released. James told him to release them. Walter walked back to the truck and paid the crew and sent them on their way. James opened the folder on the hood of Aaron's patrol unit. Aaron had offered the hood without being asked, which James took as confirmation that the deputy had understood from the GIS review that this was a documentation matter rather than an enforcement one. He laid the documents out in order: the deed for parcel MC-1987-0041, the main lake house parcel, August 1987, the deed for MC-1987-0042, the carriage house parcel, August 1987, the deed for MC-1987-0043, the lakefront access parcel, June 1989, the deed for MC-1987-0044, the road parcel, August 1987, the 1994 donation instrument, 2 pages, the county deed book reference at the top, the recording date stamped in the lower right corner, the tax records for all 4 parcels, current year assessments, payment history going back 10 years, all 4 parcels current on taxes with no delinquency, the 1991 access easement, the instrument the developer had recorded when the first phase of Harborview Estates was platted, granting the 18 lots non-exclusive vehicular access across the road parcel. He walked Aaron through them in sequence. Aaron read each document, not skimming, reading, the same way he had read the GIS data in the unit. The careful attention of a deputy who understood that the document was the record, and the record was what mattered. When they reached the 1994 donation instrument, James slowed down. The donation instrument was the document that explained everything about Alderman Point Road, and who owned what beneath it. Walter's father, Harlan Greer, then 71 years old, the deed executed in March of 1994, had conveyed the road surface to Macon County in the manner of a landowner who had spent decades maintaining a road that served other people's properties, and had decided the county should bear that cost going forward. The instrument conveyed the road surface, the pavement, the gravel shoulders, the drainage structures, the signage. It conveyed the county's right to maintain, repair, and improve all of those elements. It conveyed the obligation to maintain. Once accepted, the county was responsible for the road surface in perpetuity. What it did not convey was the land. James pointed to the reservation clause on page 2. He read it aloud for Aaron. The grantor hereby retains fee simple title to the road parcel. identified in the Macon County tax records as parcel MC-1987-0044, subject only to the county's surface maintenance easement granted herein, and the access easement of record at Book 28, page 441. He let Aaron read it himself. Aaron read it twice. He looked at the parcel number, MC-1987-0044, the same parcel number on the deed James had laid out 2 documents earlier, the same parcel number the GIS had shown as the road corridor. He looked at the reservation language. He looked at the phrase, fee simple title. James told him what fee simple title meant in the context of this instrument. Walter Greer owned the land. The county owned the maintenance obligation for the surface. The land beneath the pavement, the land on which the pavement sat, the 30-foot buffer strips on each side of the center line, all of it was Greer family land, recorded as such in 1987. The fee interest never conveyed to anyone. Aaron asked about the access easement referenced in the reservation clause, Book 28, page 441. James produced it from the folder. The 1991 access easement, the instrument the developer Bryce Tillman had recorded when he platted the first phase of Harborview Estates. It granted the 18 Harborview Estates lots non-exclusive vehicular access across the road parcel. It granted the right to drive on Alderman Point Road to reach their homes. It contained a maintenance contribution clause on page 3, an annual access fee payable to the road parcel owner. The fee set at $1,200 per year in 1991, with an inflation adjustment provision. Aaron read the maintenance contribution clause. He read the inflation adjustment provision. He looked at James. James told him the HOA had paid the access fee through 2018. He told him the HOA had not paid it since. He told him the current year's fee, adjusted for inflation from the 1991 base, was $2,100, and that 7 years of non-payment represented $13,800 in arrears before interest. Aaron looked at Beverly Marsh, who was standing 20 feet away at the edge of the driveway. She had been on her phone since James arrived, calling, James surmised, the HOA's attorney. The HOA's attorney arrived at 6:03 p.m., 12 minutes after James. His name was Douglas Farr. He had a 2-partner general practice in the county seat, wills, business formations, some residential real estate closings, the occasional dispute that stayed below the litigation threshold. He had been the Harborview Estates HOA's attorney for 4 years, handling the routine matters that arose in an 18-lot covenant community, enforcement letters, the occasional covenant interpretation question, the amendment the board had made to the exterior standards in 2022. He had not, in 4 years, been called to a property dispute on scene at 6 p.m. on a Wednesday. He parked behind James's car and walked to the front of Aaron's unit, where the documents were laid out on the hood. He introduced himself to James. They knew each other by name and reputation. The county seat's legal community small enough that practitioners in different specialties crossed paths regularly. He looked at the documents on the hood. James told him to start with the road parcel deed and work forward to the donation instrument. Douglas read them in the order James indicated. He read the deed. He read the donation instrument. He read the reservation clause. He read the access easement. He read the maintenance contribution clause and the payment history summary James had included in the folder, the column showing annual payments through 2018 and the column showing zeros from 2019 forward. He was quiet for a long time after he finished. He looked at the road parcel deed again, the recording date, the parcel number, the fee simple vesting in Walter Greer. He looked at the donation instrument's reservation clause. He looked at Alderman Point Road, the road he had driven in on, the road whose surface the county maintained on land that belonged to the man standing 12 feet away with his property files in a folder. He asked James when Walter had returned to the property. James told him today, this afternoon. Douglas asked whether Walter intended to exercise any rights under the road parcel fee interest. James told him Walter intended to enforce the access easement's maintenance contribution clause, and to receive a written acknowledgement that the HOA held no covenant authority over his 4 parcels. Douglas looked at the access easement's maintenance contribution clause again. He looked at the $13,800 arrears figure. He looked at James. He said nothing for a moment. Then he told James he would need to speak with his client. He walked to Beverly Marsh. James watched the conversation from the hood of the patrol unit. He could not hear what Douglas was saying, but he could read Beverly's face across 30 feet of driveway. The shift in her expression from the certainty she had arrived with to something that was not certainty, a recalibration happening in real time as her attorney told her things about the legal situation that she had not known when she called 911 at 4:47 p.m. Aaron Fitch closed his field notebook at 6:31 p.m. He had the documentation he needed, and the picture was clear. The property at the Alderman Point Lake House address was owned by Walter Greer, deed confirmed, recording date confirmed, ownership current. The road parcel was owned by Walter Greer, deed confirmed, donation instrument confirmed, fee interest reservation unambiguous. The HOA's maintenance activity on Walter's property was based on a board resolution, not a recorded instrument, not a court order, not a statutory abandoned property proceeding. The individual Beverly Marsh had reported as a possible trespasser was the property owner of record. He walked to Beverly. He told her he was closing the call. He told her there was no trespass. The individual was the owner of record on the property, and the county's GIS and deed records confirmed his ownership. He told her the question of the HOA's maintenance activity on the property and the access easement arrears were civil matters for the parties and their attorneys to resolve. Beverly asked him if there was anything he could do about the situation. He told her the situation was a property law matter and that his role on this call had been to determine whether a crime was occurring. He had determined that no crime was occurring. He was closing the call. She looked at the violation notice on her clipboard. She had filled it in before she arrived. The fields completed, the compliance deadline written in, the certainty of a person who had never found the deed index inconvenient before. She looked at the road outside the driveway. She looked at the GIS printout Aaron had given her 40 minutes earlier, still in her hand, the road parcel boundary visible as the corridor running beneath every foot of pavement on Alderman Point. Aaron got in his unit. He logged the call closed at 6:34 p.m., 1 hour and 45 minutes after Beverly's call to dispatch. The call notes he entered were brief and factual. Responded to report of possible trespass. Property owner confirmed on scene with deed documentation. No trespass found. Civil matter referred to parties' counsel. He drove out on Alderman Point Road. Walter Greer's road parcel, the county's pavement, the reservation clause in the 1994 donation instrument, doing its quiet work in the deed index, the same way it had been doing it since Harlan Greer signed the instrument 31 years ago. He turned onto the county road and drove toward the next call. Walter was on the porch when James came to find him, sitting in the chair his father had kept on the porch since 1963, the lake visible through the tree line in the August evening, the water going dark as the light fell. He had a glass of water. The moving boxes were stacked in the living room behind him, the furniture in its first approximation of position, the house smelling of the open windows and the lake air. James sat in the other chair. He laid the folder on the porch rail between them. He told Walter the call was closed. He told him Douglas Farr had asked about the road parcel and had received accurate answers. He told him the HOA's attorney now understood the legal situation and would be giving Beverly Marsh an accurate account of it, which was something she had not had at 3:44 p.m. when she walked to the property line with the violation notice. Walter told him he had no interest in making life difficult for the 18 households on the point. He told him they were his neighbors, and they used the road in good faith, and he had never had any complaint with them. James told him the access fee arrears were a real claim, and the boundary acknowledgement was a reasonable ask, and that Douglas Farr, now that he had read the instruments, would be advising his client accordingly. Walter told him to draft the demand letter when he was ready. James told him he would have it done by Friday. They sat on the porch for a while after that without talking. The lake was quiet in the August evening, the water still, the dock at the lakefront access parcel visible through the tree line, the Harborview Estates homes lit on the eastern shore across the cove. Walter's 340 feet of Caldwell Lake shoreline ran along the edge of his property between the moving boxes and the water. He had been gone 3 years. He was home. The deed said what it had always said. The 1991 access easement was 3 pages long. It had been drafted by Bryce Tillman's development attorney, a Charlotte firm that handled the legal work for Tillman's residential projects across western North Carolina, and recorded in the Macon County Deed Index in November 1991, the same month the Harborview Estates covenants were recorded, and the same month the first phase lots were offered for sale. The easement was the legal instrument that made the 18 lots viable as residential property. Without the right to drive across Walter Greer's road parcel, the lots had no access to the county road, and property without road access was not residential property in any practical sense. Bryce Tillman had known about the road parcel when he purchased the 18 lots from Harlan Greer in 1990. The purchase agreement had addressed it. Harlan had been explicit that the road parcel was not part of the sale, that the fee interest would remain in the Greer family, and that the development's access would be governed by a recorded easement with a maintenance contribution requirement. Tillman had accepted those terms because he had no alternative. Without Harlan Greer's cooperation on the easement, the development was not viable. With it, the 18 lots had permanent, recorded access to the county road, and a maintenance contribution structure that was, on its face, reasonable. The 18 households whose primary road access ran across the Greer road parcel would contribute to its upkeep. The easement's maintenance contribution clause was on page 2. It was specific. The easement holder, defined as the Harborview Estates HOA and its successors, would pay an annual access fee to the road parcel owner on or before January 31st of each year. The initial fee was $1,200, set at a level reflecting the road parcel's maintenance costs in 1991. The fee would adjust annually by the percentage change in the Consumer Price Index for the prior calendar year, rounded to the nearest $50. The adjustment provision had been the Greer family attorney's insistence. Harlan Greer had not wanted a fixed fee that inflation would erode to irrelevance over the decades the easement would run. Applied to the 1991 base fee across 33 years of cumulative inflation, the current year's fee was $2,100. The HOA had paid it every year from 1992 through 2018, 27 consecutive annual payments, each arriving at the road parcel owner's address before the January 31st deadline, each in the correct inflation-adjusted amount. The payment history in James's folder showed 27 consecutive entries, and then 7 consecutive zeros. The last payment had been the 2018 fee, paid in January of that year by the HOA president, who retired in the spring of 2019. The 2019 fee had never been invoiced by the previous road parcel owner. Walter had been managing his health situation, and the property management arrangement had not included the easement fee administration, and had never been paid. The institutional knowledge had retired with the president who held it. The new board had not known the obligation existed. Beverly Marsh, who joined the board in 2020 and became president in 2022, had apparently never reviewed the recorded instruments that governed her community's access to its own road. 7 years of non-payment. The 2019 through 2025 fees at their respective inflation-adjusted amounts, totaling $13,800 before interest. James had asked Beverly for the HOA's documentation of the abandoned property maintenance program, while Aaron Fitch was still on scene. The request made in the measured tone of an attorney gathering facts rather than challenging positions, the tone that invited production of documents rather than defensiveness about their absence. Beverly had said she had the policy document in the HOA's records and would need to retrieve it. James had told her he would wait. She had gone to her car and returned with a single page, a printed document on Harborview Estates HOA letterhead, the date showing 14 months earlier, the header reading, Board Resolution, Community Standards Maintenance Program. James read it, standing at the hood of Aaron's patrol unit. The resolution stated that the Harborview Estates HOA Board of Directors, in the interest of maintaining community standards and property values on Alderman Point, authorized the community's maintenance contractor to conduct exterior maintenance activities, lawn mowing, gutter cleaning, light landscaping, on any property within the community's area of responsibility that appeared visibly unoccupied for a period exceeding 6 consecutive months. The resolution stated that such maintenance would be conducted at the community's expense as a service to the overall appearance of the point. It was signed by Beverly Marsh as president and 2 other board members. James read it twice. He looked at the date. He looked at the phrase, area of responsibility. He looked at Beverly. He asked her which attorney had advised the board that a private HOA resolution authorized maintenance activity on property that was not within the HOA's covenant boundary. Beverly told him the board had made the decision in the community's interest. James asked her again, more specifically, whether any attorney had reviewed the resolution before the board adopted it, and confirmed that the HOA had legal authority to conduct maintenance activity on properties outside the Harborview Estates recorded plat. She told him Douglas Farr was the HOA's attorney. James looked at Douglas Farr, who was standing 10 feet away and who had been present for this exchange. Douglas told James the resolution had been adopted before he became the HOA's attorney. He said it in the tone of a man making a factual clarification rather than avoiding responsibility, and James accepted it as such. The resolution was 14 months old, and Douglas had taken on the HOA representation 8 months ago, which placed the resolution squarely in the period before his involvement. James folded the resolution and put it in his folder. He did not say what he was thinking about the legal quality of the document he had just read, because this was not the moment for that conversation, and Douglas Farr, having now read the road parcel deed and the access easement, did not need to be told. Walter had listened to the document review from the porch. He had not joined the group at the hood of Aaron's patrol unit. James had told him he did not need to be there for that part, and Walter had accepted the guidance, going back to the porch and the chair his father had kept there since 1963. He had watched the exchange from a distance that gave him a clear view of the expressions without putting him in the conversation. He had watched Beverly produce the resolution. He had watched James read it. He had watched Douglas Farr's expression during the exchange that followed. He had read people across property situations for 41 years, and he understood what Douglas's expression meant. The attorney had just learned something about his client's position that his client had not known to tell him. Aaron had closed the call and driven out. Douglas had spoken with Beverly for 10 minutes after Aaron left. A private conversation at Beverly's car, James giving them the distance appropriate to an attorney-client exchange. Then Douglas had walked back to James and told him he would be in contact after he had reviewed the instruments fully and conferred with his client. James had told him he would be sending a demand letter within the week. Douglas had nodded and gone back to his car. Beverly had driven out without speaking to Walter. James came to the porch after Beverly and Douglas had gone. He had told Walter then, the summary delivered from the other porch chair, the access fee arrears, the resolution's legal deficiency, Douglas's acknowledgement that he needed to review the instruments before responding. He had told Walter he would draft the demand letter by Friday. They had sat on the porch until the light was completely gone from the lake. Then James had driven back to the county seat, and Walter had gone inside to his moving boxes. That had been 3 days ago. On Saturday morning, James arrived at the lake house at 9 a.m. with his laptop in the folder and the draft demand letter he had completed Friday afternoon and reviewed twice before printing. He set up at the kitchen table. Walter had unpacked the kitchen by Thursday. The plates and glasses in the cabinets, the coffee maker running, the table clear enough to work at. James opened the folder and went through the demand letter's structure with Walter, paragraph by paragraph. The letter was addressed to Douglas Farr as the HOA's attorney of record, with a copy to Beverly Marsh as HOA president. The first section established the factual record. Walter Greer's ownership of all 4 Alderman Point parcels, the recording dates, the 4 parcel numbers, the deed book and page references. It noted the HOA's formation date, November 1991, and the 4-year gap between that date and the oldest Greer deed. It stated that none of Walter's 4 parcels were within the Harborview Estates recorded plat, and that none were subject to the HOA's covenant authority. The second section addressed the access easement. It cited the instrument by book and page. It quoted the maintenance contribution clause. It provided the payment history, 27 annual payments through 2018, 7 years of non-payment from 2019 through 2025. It calculated the arrears, the annual fees at their respective inflation-adjusted amounts for each year, the total arrears of $13,800, the interest calculated at the North Carolina statutory rate from the respective due dates, the total demand including interest, $14,600. James told Walter he had been conservative on the interest calculation. He had applied simple interest at the statutory rate rather than compounding, which was defensible, and which reduced the amount to a figure that Douglas Farr could recommend his client pay without the number becoming the primary obstacle to resolution. The third section addressed the abandoned property resolution. James had written it with the precision of an attorney who had read the resolution and knew exactly what it was and what it was not. It stated that the HOA's board resolution of 14 months prior purporting to authorize maintenance activity on properties within the community's area of responsibility, had no legal force with respect to Walter's parcels, which were outside the HOA's covenant boundary and over which the HOA held no authority, recorded or otherwise. It noted that no court order, statutory abandoned property proceeding, or recorded instrument authorized the HOA's maintenance contractor to access Walter's property. It stated that the maintenance activity, while not damaging to the property, had been conducted without authorization and must cease immediately. The fourth section stated Walter's demands, 3 items, numbered. 1. Payment of $14,600 in access easement arrears within 30 days. 2. Immediate cessation of any maintenance, inspection, or other activity by the HOA, its board, its officers, or its contractors on any of Walter's 4 Alderman Point parcels. 3. Execution and recording of a boundary acknowledgement, a document confirming in the Macon County Deed Index that the HOA held no covenant, aesthetic, or access authority over Walter's 4 parcels beyond the recorded 1991 access easement. The letter noted that Walter was not seeking damages for the maintenance activity that had occurred. The HOA's crew had mowed the lawn and cleaned the gutters, and the work had not harmed the property, and Walter was not the kind of man who filed claims for harm that had not occurred. He was asking for the access fee he was owed, the cessation of activity he had not authorized, and the recorded acknowledgement that the deed index had always supported. The letter did not threaten litigation in its first line. It stated that if the demands were not met within 30 days, Walter's legal options included a breach of easement claim for the unpaid maintenance contributions, a trespass claim for the unauthorized maintenance activity, and such other relief as the court found appropriate. It stated these options in the conditional voice, not as threats, but as the accurate description of what the legal situation supported. James read the final paragraph aloud to Walter. Mr. Greer's preference is a straightforward resolution that reflects what the recorded instruments have always shown. The deed index is clear. The access easement is clear. The HOA's covenant boundary is clear. We invite your client to read those documents and respond accordingly. Walter told him to send it. James sent the letter certified mail to Douglas Farr's office and first-class mail to Beverly Marsh at the Harborview Estates clubhouse address on Monday morning. He called Walter at noon to confirm it had gone out. Walter was on the dock at the lakefront access parcel, the dock his father had built in 1963, and that Walter had maintained and rebuilt in sections over the decades. The dock that extended 40 feet into Caldwell Lake from 340 feet of shoreline that had been in the Greer family since 1962. He had spent the morning unpacking the office boxes and the afternoon on the dock because after 3 years away from Caldwell Lake, he was not ready to be inside when he could be outside. He told James thank you. He told him the letter said what needed to be said. James told him Douglas Farr was a reasonable attorney who had now read the instruments and that he expected a substantive response within the 30-day window. He told Walter the question was not whether Douglas would advise Beverly to settle. He was confident the advice would be to settle, but whether Beverly would take the advice. Walter told him he thought she would take it. James asked him why. Walter told him because Douglas had been standing at the hood of a patrol unit, reading the road parcel deed, when he understood for the first time what his client had done. And that expression, the quiet recalibration of an attorney learning the facts his client had not given him, was the expression of a man who was going to give his client a complete and accurate account of the situation, and not soften it for the sake of the client's feelings. James told him he hoped he was right. Walter told him 41 years of real estate work had given him a reasonable read on attorneys and their clients. He sat on the dock for another hour after the call ended. The lake was flat in the August afternoon, the water clear at the dock's edge, the Harborview Estates rooftops visible across the cove on the eastern shore. 18 households, 18 families who drove across his road parcel every day to get to their homes, and who had, for 7 years, not paid the access fee that the recorded instrument required. He had no anger about it. He had been absent. The obligation had been forgotten. The board had changed, and the institutional knowledge had not been transferred, and the fee had simply stopped being paid, the way things stopped being paid when no one remembered they were owed. He was going to be paid now. The demand letter was in Douglas Farr's certified mail queue. The instruments were in the deed index where they had always been. The lake was quiet in the August afternoon. Walter sat on the dock his father had built and watched the water and waited for the 30-day window to run. Douglas Farr called Beverly Marsh on Saturday morning, 3 days after the scene on Alderman Point Road, 2 days after the certified mail envelope from James Whitfield had arrived at his office, and he had sat at his desk and read every document in it twice. He had read the demand letter first, then set it aside and read the instruments in the order James had organized them. The 4 deeds, the 1994 donation instrument, the reservation clause, the 1991 access easement, the maintenance contribution clause, the payment history, the board resolution. He had read the resolution last because he had wanted the full legal context of the recorded instruments in place before he read the document his client had produced as her authority for 18 months of maintenance activity on property she had no covenant claim over. He had read the resolution and sat with it for a while. Then he had pulled the Harborview Estates covenant document, the full governing instrument, the one Beverly had been operating under for 2 years as HOA president, and read the jurisdiction definition. The covenants define the HOA's authority as extending to the properties within the Harborview Estates recorded plat, identified by lot number, plat book, and page. He had pulled the plat from the county recorder's online database and confirmed what James's demand letter stated. None of Walter Greer's 4 parcels appeared in the plat. They were not listed. They were not referenced. They were outside the plat boundary by a clear margin. The covenants did not reach Walter's property. They had never reached it. Beverly Marsh had been operating for 2 years on the assumption that the HOA's jurisdiction extended to everything visible from Alderman Point Road, and the covenant document she governed under did not support that assumption on any page. He had called his malpractice insurance carrier Friday afternoon, not because he had done anything wrong. The resolution had been adopted before his representation began, but because he had been practicing long enough to know that the call you made before the problem became a crisis was easier than the call you made after. His carrier had told him what he already knew. His exposure was limited because the resolution predated his involvement. The HOA's exposure was what mattered. He called Beverly at 9 a.m. on Saturday. She answered on the second ring. He could hear the lake in the background. She was outside, somewhere on Alderman Point, the particular ambient quality of an open lakefront morning, audible behind her voice. He told her he had read the documents. He told her he needed to give her an accurate picture of the HOA's legal position before the board meeting, because the board needed to make its decision with complete information rather than the incomplete information it had been operating on. He told her the HOA's position on Walter's parcels was untenable. He used that word because it was the accurate word, and because Beverly was the kind of client who needed precision rather than softening. Softening would produce negotiation, and there was nothing to negotiate about the underlying facts. He told her the 4 parcels predated the HOA's formation by a minimum of 2 years. He told her none of them were in the recorded plat. He told her the covenant document's jurisdiction definition was clear, and that it did not reach Walter's property. He told her the abandoned property resolution, the document she had produced on scene as the HOA's authority for 18 months of maintenance activity, had no legal force over properties outside the covenant boundary. A board resolution was an internal governance document. It authorized the board to act within its jurisdiction. It could not expand the HOA's jurisdiction beyond what the recorded covenant defined. Beverly started to say something about community standards. He told her he understood the community standards rationale. He told her the rationale was reasonable on its face, and that he believed the board had acted in good faith. He told her good faith was not a legal defense when the action taken exceeded the authority the governing documents conferred. She was quiet. He told her the access fee arrears were a valid claim. He told her the 1991 access easement's maintenance contribution clause was a recorded obligation, that it had been paid for 27 consecutive years, and that 7 years of non-payment was a material breach of the easement's conditions. He told her $13,800 in arrears plus interest, the $14,600 James Whitfield had demanded, was the minimum exposure, and that if Walter pursued the claim through litigation, the HOA would also be responsible for his attorney's fees if the court found the breach willful, which 7 years of non-payment on a recorded obligation with a documented payment history made a reasonable finding. Then he told her the thing he had been building towards since the beginning of the call. He told her the road parcel issue was the one that concerned him most. He explained it the way he had worked it out himself during the Friday afternoon spent with the documents, the architecture of the situation that Beverly had been unaware of when she drove to the property line with the clipboard, that the 18 Harborview Estates households had been unaware of for 35 years, that the deed index had been showing anyone who looked since 1987. 18 HOA lots, 18 households, every one of them accessing their property by driving across Walter Greer's road parcel every time they came or went. Every vehicle, family cars, contractor trucks, delivery services, the HOA's own maintenance contractor, who had been mowing Walter's lawn, had been traveling on Alderman Point Road, on the county's pavement, on Walter Greer's land. The access easement authorized that travel. It was a recorded easement, it ran with the land, and it gave the 18 lots the right to use the road parcel for vehicular access to their properties. That right was real, and Walter had never contested it, and the 18 households had been using it in good faith for 35 years. The maintenance contribution clause was the condition attached to that right. The annual access fee was the consideration the easement holder paid for the use of someone else's land. 27 years of payment had been made. 7 years had not. A court looking at that record, a recorded easement with a defined payment obligation, 27 years of compliance, 7 years of non-compliance, would not look favorably on the HOA's position. The payment obligation was clear, the breach was documented, and the HOA's only defense was that it hadn't known the obligation existed, which was not a legal defense to a recorded instrument. He told her the more concerning possibility was what a court might do with the access easement if it found the breach sufficiently material. He told her he was not predicting that outcome. Walter had not threatened easement termination. His demand was for payment and acknowledgement, not for a termination proceeding. But he wanted Beverly to understand the full landscape of what the road parcel situation represented. He told her that 18 households' access to their homes ran through a recorded easement on Walter Greer's land, and that the HOA had not been paying the required consideration for that access for 7 years. Beverly was very quiet for a moment. She asked him whether they could challenge Walter's ownership of the road parcel. He told her the fee interest had been in the Macon County Deed Index since August of 1987. He told her the reservation clause in the 1994 donation instrument was unambiguous. He read it to her from the copy in the demand letter package. He told her the county's own GIS system reflected the ownership, which was why the deputy on scene had been able to confirm it on his MDT without leaving his patrol unit. He told her there was nothing to challenge. She asked him what the board's options were. He told her the board had one option that he could recommend in good conscience: full settlement on the terms James Whitfield had outlined, payment of the arrears, cessation of maintenance activity on Walter's parcels, and the recorded boundary acknowledgement. He told her the acknowledgement, while it felt like a concession, was actually a document that protected the HOA going forward. It put on record the clear boundary between HOA authority and the Greer parcels, which would prevent a future board from making the same mistake Beverly's board had made. She asked him how she was supposed to present this to the board. He told her he would present it himself. He told her to call an emergency session. The emergency board meeting was held on the following Tuesday evening. 7 board members around the table in the clubhouse meeting room, the room that smelled of the particular combination of lake air and coffee that all lakefront clubhouses seem to develop over decades of evening meetings. Douglas Farr sat at the head of the table with the document package in front of him. Beverly sat to his left. The other 5 board members sat around the table with the expressions of people who had been told the meeting was important without being told why. Douglas presented for 40 minutes. He covered the 4 parcels and their recording dates. He covered the road parcel in detail: the deed, the donation instrument, the reservation clause, the GIS confirmation. He covered the 1991 access easement and the maintenance contribution clause, and the 27-year payment history and the 7-year gap. He covered the abandoned property resolution and its legal deficiency with respect to non-member properties. He was precise, and he was complete, and he did not soften the HOA's position. He had been practicing long enough to know that a board making a decision needed accurate information, rather than a presentation engineered to reach a particular conclusion. The board's decision needed to be genuinely informed. One board member, Tom Hendricks, Lot 7, a retired banker who had served on the board for 6 years, asked whether the maintenance activity on Walter's property constituted trespass. Douglas told him technically yes, absent a recorded instrument or court order authorizing it. Maintenance activity on non-member property was an unauthorized entry. He told him Walter had explicitly stated he was not pursuing a trespass claim. The demand letter said so clearly, but that the legal character of the activity was what it was. Another board member, Patricia Vaughn, Lot 11, who had joined the board the year Beverly became president, asked why the access fee obligation had not been on the HOA's financial records. Beverly said the prior president had managed that payment. Patricia asked whether there was any documentation of the obligation in the HOA's records, any reference in the prior meeting minutes, any line item in the historical budgets, any note in the transition materials when the prior president retired. Beverly said she had not found any. Patricia looked at Douglas. She asked him what the board's exposure was if they did not settle. Douglas told her the minimum exposure was $14,600 in arrears and interest, plus Walter's attorney's fees if the court found willful breach, plus the cost of the HOA's own litigation defense. He told her the more significant exposure was reputational and relational. The HOA's 18 households depended on an easement across Walter Greer's road parcel for access to their homes, and a litigation posture against the road parcel owner was not a position a community in that dependency relationship could sustain comfortably. Beverly asked the final question she had asked Douglas on the phone, whether the road parcel ownership could be challenged. Douglas told the board the same thing he had told Beverly. He read the reservation clause from the 1994 donation instrument. He told them the clause had been in the deed index for 31 years. He told them there was nothing to challenge. Tom Hendricks moved to authorize full settlement, payment of $14,600, and execution of the boundary acknowledgement, and to direct the board president to sign the acknowledgement on the HOA's behalf. Patricia Vaughn seconded. The vote was called. 5 in favor, 1 abstention. A board member on Lot 3 who said he wanted to consult his own attorney before voting. Beverly did not vote. The motion carried. James Whitfield received Douglas Farr's call on Wednesday morning, 8 days after the demand letter had been sent, 22 days inside the 30-day window. Douglas told him the board had authorized full settlement. He told him the HOA would pay the $14,600 within 14 days, and would execute the boundary acknowledgement in the form James had proposed. James called Walter at the lake house. Walter was on the porch with his coffee, the September morning cool enough to require a jacket now, the lake visible through the tree line in the early light. James told him the HOA had agreed to full settlement. He told him the check and the signed acknowledgement would be at his office within 14 days. Walter asked him if Beverly had signed the acknowledgement. James told him she had. As HOA president, her signature was required on the board's official documents. She had signed. Walter told him to record the acknowledgement as soon as the check cleared. James told him he would. The check arrived at James's office 11 days later, drawn on the Harborview Estates HOA operating account, in the amount of $14,600, the memo line reading, Access Easement Arrears 2019 to 2025 with interest, full settlement. James deposited it and waited 3 business days for the clearing confirmation. When it cleared, he called Walter. Then he drove to the county recorder's office and recorded the boundary acknowledgement. Macon County Deed Book 41, page 203. The acknowledgement was 2 pages. James had kept it short because the facts it needed to state were simple. It identified Walter's 4 parcels by number and deed book reference. It identified the Harborview Estates HOA by its corporate filing number with the Secretary of State. It stated that the HOA acknowledged it held no covenant authority, aesthetic authority, or access authority over any of Walter Greer's 4 Alderman Point parcels beyond the non-exclusive vehicular access granted by the 1991 easement at Book 28, page 441. It stated that the HOA's abandoned property maintenance program, as adopted by board resolution, did not apply to Walter's parcels, and that no such maintenance activity would be conducted on his parcels without his written consent. It was signed by Beverly Marsh as president of the Harborview Estates HOA and acknowledged before a notary. The recorder's stamp went on the first page, received, indexed, recorded. Book 41, page 203. cross-reference to the 1991 access easement at Book 28, page 441, and to the 4 Greer parcel deeds. Anyone pulling the Macon County Deed Index for Alderman Point would now find 5 documents in the Greer-Harborview cross-reference: the 1991 access easement, the 1994 donation instrument, the reservation clause, and now the boundary acknowledgement that said in the official record what the deeds had always said in fact. Beverly Marsh did not appear on the HOA's December election ballot. She had told the board in October that she would not be seeking a 3rd term. She gave the board no specific reason. She had been HOA president for 2 years, and in those 2 years, she had expanded the HOA's maintenance program to cover properties outside its covenant boundary, had called 911 on a property owner moving into his own home, had discovered in the presence of a sheriff's deputy that the man she was reporting owned the road she had driven in on, and had signed a recorded acknowledgement confirming that the HOA she led held no authority over 4 parcels it had been treating as subject to its jurisdiction. She had served the community according to her understanding of its interests. Her understanding had been incomplete. She did not seek a 3rd term. The December election would produce a new president. The acknowledgement would be in the deed index when they took office. The access easement's maintenance contribution clause would be in the deed index. Walter Greer's 4 parcel deeds would be in the deed index. The next HOA president would not be starting from Beverly's position of incomplete information. The deed index had a way of preventing that. The September morning came in off Caldwell Lake, the way September mornings came in off mountain lakes in western North Carolina. Cool and still, the water holding the last of the summer warmth below a surface that had gone glassy overnight, the mist that had been on the lake at first light, already burning off by the time the sun cleared the eastern ridge. Walter had been awake since 6. He had made the coffee the same way he had made it since he was in his 30s, the same grind, the same ratio, the same unhurried process that belonged to the part of the morning before anything was required of him. And he had carried the mug to the porch and sat in his father's chair. He had been home for a year. The Raleigh apartment was gone. The lease terminated in October of the previous year. The forwarding address changed to the Alderman Point Road Rural Delivery Box. The last of the administrative connections to the city severed in the way you severed them when you were not visiting a place anymore, but living in one. The cardiologist had cleared him for the move. The property manager's monthly check reports had ended when Walter stopped needing them. The lake house was his primary residence in the legal sense, the address on his driver's license, the address on his tax return, the address to which his mail arrived, and in the more important sense, which was that this was where he woke up every morning and sat on the porch with the coffee and watched the light come onto Caldwell Lake. The lake was flat and still at this hour. The water moved at the shoreline in the small, repetitive motion that a lake made when there was no wind, and the surface was responding only to its own internal circulation, a gentle pulse at the edge of the dock, the water rising an inch and falling an inch on the dock's lowest board. The Harborview Estates homes were visible across the cove on the eastern shore, the rooftops through the tree line, the docks extending into the water, the lights on in the early morning windows of households beginning their days. His neighbors, 18 of them, on 18 lots, in the community that had been operating on Alderman Point for 35 years without his interference, and that would continue operating without his interference for as long as he owned the road parcel and they paid the access fee. He sat with the coffee and the quiet and the lake. The Macon County Deed Index for Alderman Point was a longer document than it had been a year ago. It had always contained the 4 Greer parcel deeds, the 2 from August 1987, the 3rd from June 1989, all of them recorded before the first Harborview Estates lot was sold. It had contained the 1991 access easement, the instrument that made the 18 lots viable by granting their owners the right to drive across Walter's road parcel. It had contained the 1994 donation instrument and its reservation clause, the 2-page document that had conveyed the road surface to Macon County and retained the fee interest in the Greer family, the document that the HOA's board had never read and that Aaron Fitch had confirmed on his MDT in 34 seconds on a Wednesday afternoon in August. It now contained 2 more entries: the settlement payment record, the $14,600 check drawn on the Harborview Estates HOA operating account, deposited, cleared, the transaction complete, and the boundary acknowledgement at Book 41, page 203, the document Beverly Marsh had signed as president, acknowledging in the official record of Macon County what the deeds had established in 1987 and what the covenants had established in 1991, and what the reservation clause had established in 1994, and what the GIS system had confirmed for Aaron Fitch in the front seat of his patrol unit. Walter Greer owned 4 parcels on Alderman Point. None of them were subject to the Harborview Estates HOA's covenant authority. The HOA held access rights across the road parcel under the 1991 easement and nothing more. Anyone pulling the index for Alderman Point now found the complete picture: the deeds, the easement, the donation instrument, the acknowledgement. The legal architecture of the point was documented at every point where documentation was possible. The gaps that Beverly Marsh's boardroom had operated in, closed and recorded and permanent. James Whitfield had called Walter the afternoon the acknowledgement was recorded. He had told him it was in the index. Walter had thanked him. He had sat at the kitchen table with the property folder open in front of him and the 4 parcel deeds laid out, and had written on an index card in his careful, deliberate hand, the handwriting of a man who had been writing on property documents for 41 years, and who had learned to write clearly because documents that could not be read clearly were documents that caused problems. 4 parcels, 1987, predates everything, always has. He had put the card behind the acknowledgement in the folder and closed it. Thomas Arden had been elected HOA president at the December meeting. He was on Lot 14, a corner lot on the eastern shore of the point, a house he had bought in 2019 and that he and his wife had used seasonally until they retired and made it their primary residence in 2023. He had been a civil engineer for 34 years, structural work, primarily, bridges and retaining structures and the highway infrastructure that ran through mountain terrain. He had been on the HOA board for 1 year as a member at large before the December election, a period during which he had said relatively little at meetings and read a great deal between them. He had read the demand letter package before the emergency board meeting. Douglas Farr had sent the full document set to all board members, not just to Beverly, and Thomas had read every instrument in the set the evening he received it. He had read the road parcel deed. He had read the donation instrument's reservation clause. He had read the 1991 access easement and the maintenance contribution clause and the payment history. He had been a civil engineer long enough to understand recorded instruments the way engineers who worked on infrastructure projects understood them, as the legal foundation on which physical things depended, documents whose precision mattered, because imprecision in a recorded instrument had consequences that showed up in the physical world. He had voted in favor of the settlement at the emergency board meeting. He had been the second vote after Tom Hendricks. When he was elected president in December, he had done, in his first week, what Beverly had apparently not done in 2 years. He had pulled every recorded instrument touching Alderman Point from the county recorder's database and read them. All of them. The covenant document, the plat, the 1991 access easement, the 1994 donation instrument, the boundary acknowledgement, the deed cross-references. He had spent 2 evenings reading and had emerged with a complete picture of the legal architecture of the point, what the HOA governed, what it did not govern, what the easement required, and what the road parcel ownership meant for the community's relationship with Walter Greer. In his first board meeting in January, he had presented a single agenda item, the 1991 access easement's maintenance contribution clause. He had shown the board the clause, the payment history, the calculation of the current year's fee, and the line item he was proposing in the HOA's annual budget. He had told the board that the access easement was the instrument that gave 18 households their right to use Alderman Point Road, and that the maintenance contribution was the consideration attached to that right, and that paying it on time and in the correct amount every year was not optional and not discretionary, but the fundamental obligation the recorded easement imposed on the HOA as the easement holder. The budget line item passed without objection. The check, $2,100, the current year's access fee at the inflation-adjusted rate, drawn on the HOA's operating account, arrived at James Whitfield's office on January 28th, 3 days before the January 31st deadline the easement specified. On time, in the correct amount, with a cover letter from Thomas Arden on Harborview Estates' HOA letterhead noting the easement book and page reference and the payment year. No dispute letter, no methodology objection, no request for a postponement pending review. James had called Walter when the check arrived. Walter had told him to deposit it. Walter walked the 4 parcels every morning. He had developed the routine in the first weeks after his return. The morning walk as the organizing structure of the day. The property assessed on foot before the day's other demands began. He walked in the order he always walked it. The main lake house parcel first, the circuit around the house's exterior, the porch, the dock approach path, the property's southern boundary. Then the carriage house parcel, the building exterior, the equipment he kept in the bays, the northern fence line that ran along the boundary between his land and the first Harborview Estates lot. Then the lakefront access parcel, the 340 feet of shoreline, the dock, the boat storage structure, the strip of land that gave the Greer holding its complete lakefront position. He walked the road parcel last. He entered it from the lakefront access parcel's western boundary, the point where his land met the road parcel's eastern edge, and walked north along the buffer strip, the Alderman Point Road surface to his left, the county's pavement maintained and patched and running straight and functional, in the way county-maintained rural roads ran when the county took its maintenance obligations seriously. He walked the length of the buffer strip to the north end of the road parcel, the cul-de-sac at the point's tip, the turnaround where Alderman Point Road ended, the road parcel's northern boundary, a curved line matching the cul-de-sac's geometry. He turned and walked south along the western buffer strip, the lake visible through the vegetation on his right, the road to his left. The entrance monument was at the southern end of the western buffer strip. The Harborview Estates brick structure, the HOA signage, the landscaping maintained by the HOA's contractor. The monument base sat on the road parcel's buffer strip. It had sat there since 1991, placed by Bryce Tillman's development crew, without apparent attention to the fact that the buffer strip was Greer family land, rather than Harborview Estates' common area. Walter had looked at the monument in the first weeks after his return, and made a decision about it the same way his father had made decisions about the things that occupied his land without causing harm. He left it. The monument served its purpose. The HOA maintained it. It was on his land. The land beneath it was recorded as his in the deed index, and the boundary acknowledgement now made clear that the monument's presence was a courtesy rather than a right. That was enough. He passed the monument and reached the road parcel's southern boundary, the point where Alderman Point Road met the county road, the edge of his fee interest in the corridor. He stood there for a moment. 38 years. The deed had been recorded at this location in August of 1987, before Bryce Tillman had purchased the 18 lots, before the first foundation had been poured in Harborview Estates, before Beverly Marsh had moved to the county. The road parcel had been his father's land, and then his land, and it would be his land for as long as he maintained the taxes and the insurance and the records that said what they said. He turned and walked back toward the lake house. He finished the walk at the lakefront access parcel every morning, the 340 feet of Caldwell Lake shoreline, the last stop before he went back to the house, the dock, the endpoint of the circuit. He stood at the end of the dock on the September morning with the empty coffee mug and looked at the lake. The water was moving at the dock's edge in the small, repetitive motion of a still morning, the surface reflecting the early light in the way Caldwell Lake reflected light in September, the clarity of mountain lake water in the transition from summer to fall, the surface color shifting between blue and gray depending on the angle of the sun. He had stood on this dock as a child, watching the same water move. He had stood on it as a young man, as a developer in the middle of his career, as a man in his 60s who had been away for 3 years and come home to find his property intact and his ownership uncontested by anyone who had read the deed. The property folder was on the kitchen table where he had left it that morning. The 4 deeds, the donation instrument, the access easement, the settlement agreement, the boundary acknowledgement, the index card at the back. He had left it out for no particular reason other than the habit he had developed of keeping the documents accessible, the same habit that had put the property summary in his phone and the thermal printer in the truck's cab on the day he drove back to Alderman Point with the moving crew. He had no animosity toward Harborview Estates. He had no animosity toward Beverly Marsh, who had operated under a mistaken understanding of her authority, and who had learned the limits of that authority in a way that had been uncomfortable, but that had not, in the end, caused Walter material harm. He had no animosity toward the 18 households who drove across his road parcel every morning on their way to work, and every evening on their way home, and who paid the access fee now, on time, in the correct amount, under a president who had read the instruments before he took office. They were his neighbors. The easement was honored on both sides. The deed index reflected the complete picture. The lake was quiet in the September morning. He was 68 years old, and he was standing on 340 feet of Caldwell Lake shoreline that had been in his family since 1962, and he was home. He stood at the end of the dock until the sun had fully cleared the eastern ridge, and the mist was gone from the surface, and the lake was doing what a mountain lake did on a still September morning, holding the light, holding the quiet, holding the particular clarity of water that had been cold and clean for as long as anyone had been alive to describe it. Then he walked back up the dock, across the lakefront parcel, along the path to the lake house, up the porch steps, and inside. The property folder was on the kitchen table. The index card was behind the acknowledgement, where he had put it the evening the recording was confirmed. He did not take it out. He did not need to read it. He had written it once, and it said what it said, and what it said was permanent and sufficient. 4 parcels. 1987. Predates everything. Always has. The deed says what it says. The road parcel says what it says. Walter Greer owns Alderman Point, the same way he has owned it for 38 years. Completely, without encumbrance, without qualification, without a homeowners association in the Macon County Deed Index that holds any claim on it. He put the coffee mug in the sink and went to start the day.